if Kagan is President Obama's nominee, she's going to face a lot of questions about First Amendment issues, which have been occupying much of the court's attention this week. Now, earlier this week, I spoke with FiOS 1 news anchor and legal expert Stone Grissom on why the Supreme Court is so invested in crosses, dogfighting, and violent video games. Through quickly 3 Supreme Court cases here, and not just because the facts of them are sensational, maybe of the cases, but also some of the implications. Talk about the dogfighting videos.
Dogfighting videos, 8-1 decision. It was coming up. Basically, what the government wanted to do is they banned the dissemination or possession of any videos that had dogfighting in them because they didn't like. I mean, certainly there's a law against dogfighting. And the Supreme Court 8-1 struck that down and said that's a matter of free speech. Now, it's important to understand the First Amendment a little bit because certainly nobody has a right to commit a crime in order to depict it on film. You don't have a right to speed so someone can film you to do that. You don't have a right to steal a camera so someone can film a documentary. Daniel Ellsberg, who stole the Pentagon Papers, certainly could have been convicted for the theft. But the New York Times and the Washington Post could not be convicted for printing the Pentagon Papers. The actual depiction itself is free speech. There's only one exception. It happened in 1982. It was a New York case, actually went up to the Supreme Court, Ferber versus New York, and that deals with child pornography. In that case, the government said, we have a unique interest in protecting children, and there's an ongoing trauma from the dissemination of these videos to children who might be depicted in those films. And so that's an exception to the First Amendment, to that free speech. So
if you use a dogfighting case here, you can't commit the crime, but you can actually profit from the crime if you are the person selling the videos.
Look at the news. We do it all the time,
Sure.
every day. We depict brutality, acts that are potential criminal acts, robberies, surveillance tapes. That itself is free speech. The underlying act is not necessarily protected, and that's what the Supreme Court said.
Well, let's talk about something not as severe, but kind of connected, violent video games, because everybody thinks there's a problem, and it's very funny that the person who was the Terminator in Conan the Barbarian, Governor, yes, exactly, Governor Schwarzenegger, he says, no, you know what, I want 18 to be the cutoff age before anybody can buy some of these violent video games. Certainly violent, but now the court weighs in.
Right. It's a law they passed in California that went up and it was stricken down. It's now in front of the Supreme Court. They've agreed to take that same analysis here. The video industry is arguing we self-regulate ourselves. You have M for mature. We can warn people, but certainly there's a free speech right.
Dennis, you explain for me, if you want to go to a movie and it's NC-17 or something, that was arbitrarily chosen by the movie industry.
Right.
They picked that number. I thought it came from some other standard, but the movie industry picked their own number.
Right. I mean, that's
and the same thing with these video games.
I mean,
right?
that's what the movie industry. And now certainly there's pressure put on from the government. I mean, they want the movie industry to regulate itself, but there's still a free speech right. If you decide that you want your 12-year-old child, whether that's a smart thing to do or not, if you want them to watch a horror film that is rated R, you have a right to do that. You can't. The police can't bust down your door and arrest you and throw you in jail for letting your child, who may be underage, watching an R-rated film because it's free speech. You have a right to own it. You have a right to watch it, and that's certainly the case. It's going to be the same analysis, I think, going up to the Supreme Court. I think it's why they chose that. It's just somewhat ironic that Schwarzenegger's involved.
And finally, here, a bizarre case in Utah where you can choose your own method of execution. I guess the guy on death row said, "I want a firing squad."
Robert Gardner, June 13th, will be shot by firing squad. 5 people will tape him to a chair. He will have a hood placed over his head and a target placed right over his heart. 5 identical guns, one with a blank, will be pointed right at him, and they'll execute him by firing squad. Now, Utah changed that law in 2004. There are only 2 states that have the potential of a firing squad. That's Oklahoma and Utah. Utah in 2004 made lethal injection the default method. So, but there are still 10 people. Anybody sentenced before 2004 still has the right to choose the method that they want to be executed by. 10 people have that, and Gardner's one of them, and he chose it. So,
in 2010, we have firing squads in America.
1996, we had the last execution by firing squad in Utah. Utah's done it twice since 76. So I mean, it's not unheard of there. It's
fun, uplifting stuff here, Steve.
It is fun.
Thank you very much, as always.